Yes, my lord.
Yes.
On the first day of August 2023, you made an additional statement on oath at the registry of this honorable court. Can you confirm that?
Yes, my lord.
Yes.
What do you want this honorable court to do with your additional written statement on oath?
I want the court to adopt as my evidence in this case.
You are the one to adopt witness. Witness, you are the one to adopt. This court cannot adopt your.
Okay, I would like to adopt those documents as my evidence in this case. Thank you, sir.
Thank you, my lord.
Yes.
You, in your additional written statement on oath, in paragraphs 9, paragraph 6, 9, 11 onward, you refer to a couple of documents.
Yes, my lord.
Those documents you referred to, tell the court how they were procured.
My lord, those documents were procured. They were sent to me via emails and documents I obtained from the internet and documents sent to me through my counsel.
He is too fast.
You are too fast.
You should remember we are writing his
hand.
testimony.
Yes.
In a
Witness,
long hand.
you must be on record. And for you to be on record, you have to take it slowly.
Yes, he said they were sent to him.
Yes.
Those documents were obtained via emails and the internet, from the internet, and from my counsel, sent to me through my counsel.
Milo, just for the direction of the court.
Yes.
All the documents are already with the witness. So I will only want to lead him to acknowledge the document I want to tender so that I can tender it from here because it is virtual.
These documents, are they front-loaded here?
Yes, they are front-loaded,
They are front-loaded?
They are front-loaded.
Okay.
Witness.
Yes, my lord.
Recall again that on the 24th day of July, 2023, you made a certificate at the registry of this honorable court.
Yes, my lord.
The certificate relating to computer-generated documents.
Yes, my lord.
Can you confirm that?
Yes, I confirm. Yes, I confirm.
Sorry, my lord. My lord, I just want to note something. The witness is reading from his script. He's reading all the evidence he's giving. He's reading from his script. I want to notice it.
Yes. Anyway, he should not do that.
Yes, that is what he's reading on his script, sir.
No, you should not do that. You are giving evidence. Already, witness statement on oath is already before this court. You are being led to make emphasis, but not to read from any document over there.
My Lord, I'm sorry.
If that observation is correct.
It is not, my Lord. And that
If it is correct, then you should not do it. If it's not correct, then council can proceed.
That was why I earlier hinted the court that he has those documents. Ordinarily, if he's in the witness box here, I would have showed it to him. So I'm only asking him to acknowledge it. He can only acknowledge it by taking a look at the one before him. And that's what he's exactly doing, not reading from any script.
He's trying to identify them.
Yeah, exactly, my Lord.
Okay.
I'm grateful, sir.
You should have asked him to identify those documents.
As a cop,
at the beginning, you should have asked the witness those documents in his possession, his custody, if you can identify them, particularly if you can now mention them, enumerate them.
In the course of the proceedings, my Lord,
yes,
as we proceed. I'm grateful, sir.
You stopped at on 24th of July, 2023. I made a certificate relating to computer-generated documents.
Yes, my Lord.
Yes. Yeah.
And he confirmed it. My Lord, we wish to tender from the bar here a copy of that certificate.
Mr. Okon?
My Lord, I have no objection from tendering it from the bar. The certificate.
Just for the direction again, my Lord, the time is fast spent. I have a bunch of documents, and I am, my Lord, with respect, sir, suggesting that maybe my learned friend should look at those documents and identify the one he wants to object to, so that we can make better progress. Because by the time I start tendering them one after the other in line with the pleadings and evidence, my Lord, it will take a good number of time. But if my learned friend is, I'm only thinking that it's going to be faster doing it like that. Anyone who wants to object to, we can join issues as to that.
I expected that should have been done earlier than now.
I'm so sorry, my Lord.
In a trial of this nature, you have documents.
Yes, my Lord.
So these documents, sometimes you can tender them as a bundle. You should have arranged with your learned colleague, and all these things wouldn't have been a problem. Just tendering one after the other is going to be a problem. Really, it would delay. So, Mr. Okon.
Yes, my Lord.
What's your view about that?
My Lord, I am sufficiently...
these documents are already front
yes, I'm sufficiently familiar with the practice of this court.
Yes.
As objection to documents. And so my learned friend should take a cue from what the practice is.
Okay.
Tender a document that we don't have...
Very well.
I don't know what the practice that you're referring to. Because the practice of tendering those documents from the bar is also the practice of some courts, and even most courts. Exactly. And the practice of tendering one after the other is also the practice. So whichever way he wants to go, my Lord, the only thing is that I want to save the precious time, considering that we have had enough time spent today already, and we have counsel. I can see in the list there are other 2 virtual hearings yet to go on after this. But if my Lord, my learned friend insists that I do it the way I want, it should be done in litigation-wise, my Lord, I'm ready.
I don't know what my learned friend wants, what he wants me to do. I don't know whether he wants me to teach him what to do. What I
think this is not supposed to be.
Let him put the documents together and look and give it to and tender. Well, we know the practice as to admissibility and otherwise. He can put the documents. These are the bundle of documents.
Counsel, arrange the documents.
The certificate he just
you have listed them on the list of documents here.
Yes, ma'am.
Yes, they show your learned colleague. If there is anyone that he wants to object to, then he should indicate. If there is none, then you make your application so that the documents can come in.
As a couple,
yes. Just send that one. In that certificate,
yes,
there is no description of any document. It's just a document and all that. No mention of anything.
He has sent this from the bar. Let me rule on it.
Yes, my Lord. Yes. That is what is there. So when he comes, because that certificate ought to
His
identify a
position.
document coming from a particular source.
His position is in respect of the rest of the document as he wants to tender them.
Yes,
But for this one, he has tendered it from the bar, and you have not objected, and
My
I'm
lord.
about to rule on it.
Yes, my lord.
Yes. This is the first exhibit. Counsel, this is
Yes.
the first exhibit.
Yes, my lord.
you have tendered.
Yes, my lord.
The certificate relating to computer-generated document pursuant to Section 84, Sub 2 of the Evidence Act, 2011, tendered from the bar in evidence by counsel for the claimant, which application was not objected to, is hereby admitted in evidence and shall be marked as Exhibit CW1.
As the court pleases. Lord, I wish to tender 12 sets of documents Lord, the documents are graph 9,
Hold on, paragraph 6, 9,
11,
11,
12,
12,
13,
13,
14,
14,
20,
20,
22,
22,
28,
28,
30, and 31
30, and 31.
of the additional written statement on oath of the witness.
Mr. Okon? How many of them? Okay, you said there are 12 in number.
Yes, my lord.
Okay.
The one admitted as SB2A will make it 13.
Exhibit C1.
SBC1, sorry,
Yes.
C1 make it 13. I'm grateful, my lord.
Very well.
Oh. 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. My lords,
Have you seen them?
yes, my lord, I've seen them.
Yes. What's your reaction?
My lord, this document tender a bundle, they are to explain different scenarios. First, I want to be on record that the witness
Yes.
has not given, because some of these documents, for instance, letter of employment, which document number 1 is a photocopy.
You said the witness has not, and you said
Yes, my lord,
has
not laid any foundation in respect of photocopies,
has not laid
any foundation relating to these documents have here, which
relating to the background of the documents or what?
Yes. My lord, I'm
Has
sorry
not
to
been-
interject. I think my learned friend, please have your seat. Sorry. I think my learned friend is trying to jump the gun.
Cannot stand at the time.
Yes, please.
You saw the document I have in my hand.
Yes, hold on. I want to clarify what you are about to ask. If there are, I've given him my first application was if he were going to object. If he's going to object, let him sort out. I will tender those ones you want to object so that he can object.
That is the position.
So
that's the position and which I have directed.
Yes, start saying that I have not laid foundation means I've not, because I don't know the ones he want to object to. If there's anyone he wants to object
it out, find out which one are you objecting and which one you are not objecting to, and then so that we can have their list here. And the ones you are objecting to, then you set your background, your reasons.
As a copy, the documents I have in my hands are bundles. All the documents.
They are 12 in number.
They are 12 in number, bundles of documents.
You have arranged them as you have listed them.
For me to be able to relate to this document, I have to see them.
Okay, now sort it out, and then make your complaint.
As copy,
yes, sort them out.
My lord, I'm sorry, my lord, I'm so sorry. My learned friend want to just what we want to cure, he want to inflict on us. I'm sorry. Let him give me those documents so that I can tender it and the witness will lay the foundation. We'll proceed.
Are you withdrawing the application for now?
No, I'm not, because this is time consuming and time wasting. But my lord, okay, I withdraw. Let him go ahead.
What I want to know is, are you withdrawing your application for now?
Tender the document?
No, my lord.
Okay.
No, my lord.
No, it's wait.
If you want to mark it,
now. All these things will come to you. My lord.
Yes. Yes, Mr. Okon, I can hear you.
My lord, I have with me here 12 documents of different nature. Document number 1, document number 2.
Numbers 1.
Number 1 is offer of employment.
Number 1 is offer
of employment. Is a photocopy. Number 2 is certificate of incorporation of notary. A photocopy.
Certificate of incorporation of the defendant.
No, not defendant.
This is my lord, I'm sorry. This is again what I don't think is right for my learned friend to do. He cannot, for document I have not even said anything on. I have not said anything on those documents. So he cannot begin to classify them as photocopy. It is for him to select the one he wants to tender. If I could not lay the proper foundation for whatever it is, or even determine that, then he will proceed. He's already objecting. He's already objecting without me having even laid my own foundation. And that is the way I said he should select those documents he wants to object and say to me, Lord, I'm not objecting to this. Then I'll be objecting to this. Then he hand it over to me for me to tender it, and he will object.
That is the way it ought to have been done. Mr. Okon.
Yes, my lord.
Initially, he has said that he wanted to tender, to tender 12 documents, which he sorted them out. 12 documents in number, which he forwarded them to you for you to identify which one are you objecting and which one you are not going to object. Then you give him back so that he can make the proper application. For those ones that you are not objecting, then we take him. The ones you are going to object or you want to object to them in any way, then you can take it up.
We are not objecting to this. Okay. My lord, my learned friend has done well. Please, we can proceed from here. I want to tender from the bar, letter dated August 4.
I'm
grateful, my lord.
I apply to tender.
Letter dated from Komi Olaleye Chambers. Letter dated 14th.
I apply to tender from the bar.
From the bar. I'm grateful, my lord.
The following documents.
As a couple please. Letter from Komi Olaleye Chambers.
1. Letter from, how do you spell that? Letter.
Komi is Kanmi.
Or Kanmi. Okay.
Olaleye. As pronounced. Yes, sir.
Yes.
Chambers. Dated 14th August 2020.
Or 14th August 2020. 2.
And letter
from the second one. Is that the second one?
Yes, sir. It's 2.
Okay.
Letter from Notore Chemical Industries PLC.
From Notore
Industries PLC.
Number 3.
Dated September 10, 2020.
Of 10 September 2020.
Yes, my lord. And email correspondence.
That's the third one.
Yes, the third one. Yes, my lord.
Email correspondence.
4-page email correspondence of 16th June 2020.
Of 16th June.
16th June 2020.
Yes.
3rd June 2020. 6th November 2019. 6th November 2019.
There are various types.
Yes.
Various dates.
Dates. 19th of various dates, my lord.
Yes.
19th September 2019.
19th September
2019 and 30th June 2020 as exhibits in this case.
Mr. Okon?
My lord, I am only helping my learned friend. I do not know whether my...
you have heard him, you have listened to him.
Yes, my lord.
Are you opposing or you are not?
My lord, so long as he's saying that
He tended from the bar.
From the bar, my lord,
yes.
the opposition, because there's a witness in the witness box who said he referred to document, and he now said he want to tender it from the bar. I don't understand that procedure, because a document that is tenderable from the bar is different from a document in which a witness has identified.
Are they not the one that you said you are not objecting?
I don't know why my learned friend...
You have indicated these are the documents you are not opposing. The council to tender them from the bar.
The mode of the tendering of this document, my lord, is what I want to draw my lord's attention to.
Because I'm not opposing.
Please, one of you should be take a seat.
My lord, if he says the document, if a witness has identified a document, and I say I'm not opposing, he tenders it as a witness tendered by the defendant, or by the claimant, the witness in the witness box. My learned friend cannot now say he's sending those documents from the bar. He can't do that. My lord, the document tendered from the bar is the set of document that could be tendered from the bar are different from a that is tendered through a witness.
Okay.
If it's tendered from
let me be certain about this issue.
As a court pleases. My lord,
the initial position is that you look at the 12 number of documents he has given you. These documents, you look at them and you sort out. I mean, the ones that you intend to oppose, they are tendering, and the ones that you do not intend to object to their tendering. Yes. Now, are these ones among the ones that you have sorted that you are not opposing?
My lord, I will not object to this document being tendered through the witness. But if he's tendering it from the bar, my lord, my learned friend can only tender certified true copy of it from the bar as his document. He's not giving evidence. Why is he now saying, I hereby tender this from the bar? He tendered as his own document. But if he says, my lord, I will leave it. My lord to rule. My lord, I have no objection to this document.
My lord,
from the bar.
With respect to my learned friend, this is a difference without a distinction.
He is saying he is not objecting again.
My lord, the sole purpose of, even in the first place, applying to tender from the bar was on the basis of
time consciousness
and non-objection to those documents.
Yes.
The witness has already said that he referred to set of documents, and I sought to sort it out to make it easier. Those he's going to tender, so without objection, I can tender it. My lord, it's a simple. It's
That's why I drew his attention to that.
It's a difference without a distinction. But if he wants my witness to identify those documents, just for me to point to him, but that would be stretching it to a ridiculous level, because he's not objecting. And that's the reason why I'm surprised at what he's an experienced lawyer. The moment he says you are not objecting, not that the document is not admissible, not that it's not. Once you say you are not objecting, then you have waived every right that should be admitted. Even with consent of lawyers, documents can be admitted.
That is his position at this point in time.
If my learned friend insists, I'll make an application that my learned friend, the documents be admitted as documents the council tendered from the bar. My lord, I'm fine.
My lord, it is like I said before, with respect. Unfortunately, if I had started from the scratch in laying foundation, maybe by now would have finished here. The pain I wanted to take away is coming back. But my lord, let me just take the witness.
Sometimes it is worth doing the right thing.
Yes.
So that it will save time, and then the certainty will be there.
The right thing is just, I am not objecting to this document.
Certainly.
You have given me the ones you want to object.
But you can see the delay that you are trying to run away from it.
My lord, I'm so sorry. Yes. I'm so sorry. It's not intended.
But anyway, he has now indicated he's no longer opposing
as a
the tendering of those things from the bar. That's what he said. That's what he said.
Solar is on record that my learned friend is sending those documents from the bar. I have no objection to it at all.
Now, let me ask my lord for further direction. If I want to tender it through the witness, I want to know if he's going to object. It's a simple question. Will he object if I tender it through the witness?
Do your case now. Am I going to teach you your case? Present your case.
What the council is saying He is saying that if these documents were tendered through the witness, he wouldn't have raised any issue. But now that you see, this document is already sorted out. You have seen them. You have said that you are not opposing to their tendering. So in order to make use of the time very well and benefit from the time, that's why counsel said he's tendering from the bar. I think it is the same document, whether it is tendered through the witness or tendered from the bar, it is still the same document.
And it's on the record that he's not objecting.
The witness has stated that these are the documents that he has made reference to them in various paragraphs of his witness statement on oath, which is before this court. And the document is also front-loaded. It has been in your hand for a long time.
I'm sorry.
I think let me rule on this.
Yes, I want to tender it to the witness, just to avoid.
What kind of record are we having? Are we keeping here? You make an application, it is recorded.
Okay, my lord, I withdraw that application. I allow my lord to rule, at least on this stage, so that the record will be tidy. My lord, I'm so sorry, and I want to appreciate the court for the indulgence.
Very well.
From the back, without objection. After all, the letter is from their lawyer. So what is he going to say about it again? It's from their clients.
It is this kind of remarks that is always escalating, one thing or the other in the process of, hearing this matter.
I'm not going to react to any statement he makes.
What you said is that
I'm not going to react.
I am recording. You said, I do not object to the tendering of these documents
from the back
enumerated by the council from the bar. Upon an application to tender the documents listed above in evidence in this matter, which documents having not been objected to by the defense counsel, the documents are hereby admitted in evidence and shall be marked as exhibits CW 2 to 8. That is to say, letter from Kanmi Olale Chambers of 14th August 2020, exhibit CW2. Letter from Notore Chemicals Industries PLC dated the 10th day of September 2020, exhibit CW3. Email correspondences of the 16th day of June 2020, exhibit CW4. And that of the 3rd day of June 2020, exhibit CW5. The correspondence, email correspondence of 6th of November 2019, exhibit CW6. That of the 19th of September 2019, exhibit CW7. And the email correspondence of 30th June 2020, exhibit CW8 respectively.
As the court pleases.
Yes.
I'm grateful, my lord. Witness.
Yes, my lord.
Yes.
In the course of your examination in chief, which is still going on, you said those documents were procured by emails, internet, and letter and correspondence. Now you refer to in paragraph 6 and 9.
They were procured by email. You said internet,
and letter from through his lawyer. Letters through his lawyer. Yeah, that was the foundation.
Mm-hmm.
Yeah. In your additional written statement on oath, in paragraph 6 and 9, you refer to two documents. Letter of offer of employment dated the 4th day of February 2009, and letter of acceptance.
Letter of employment
dated 4th February 2009.
Mm-hmm.
And letter of acceptance.
Mm-hmm.
Dated 9th February 2009. Mm-hmm. Can you identify those documents?
Yes, my lord.
Hey, we can't hear you.
Yes, my lord. Can you hear me now?
What's happening?
Yes, my lord. Yes.
Unmute yourself. If you can hear me, unmute yourself.
I'm not muted. Yes, my lord. Can you hear me? I'm not muted at all. I can hear you.
Nobody can hear you from here. Check your end if you can hear me.
There's nothing wrong at my end. I can hear you clearly.
Okay, we can hear you now.
Yeah, I didn't do anything. Busy network.
Can you identify those two documents in paragraph 6 and 9?
Yes, my lord.
Now tell the court how that documents were procured.
Those documents were procured through email.
From which source to which source? Tell the court.
From Notore Chemical Industries PLC to iredele@yahoo.com.
From
Notore Chemical Industries Limited, then now PLC, to iredele@yahoo.com.
And that of the 9th too?
Yes, procured, sent to me from Notore Chemical Industries and then to iredele@yahoo.com.
The letter of acceptance, is it the same means? That's what I'm asking.
Yes, it is the same means. The same process. I sent it. Oh, the acceptance I sent from me, Iredele Oyedele, to Notori Chemical Industries Limited, my lord.
My lord, I most humbly. How did you get the copy of this document? Let me not go skip that line.
I printed them off from the email correspondences. And I photocopied them over.
My lord, we humbly wish to tender the 2 computer printout of letter of employment and the acceptance as exhibit.
Application to tender. To tender what?
The letter of offer dated February 4.
The letter of offer.
Dated February 4, 2009, and the other one dated 9th September 2009.
Acceptance.
9 September.
Yes, 4th September
4th
and 9th
September.
2009. And the first is 4th September, offer letter.
No, the first one is the offer letter, eh?
4th of September.
4th September or
Yes, September. Sorry.
September.
No,
February.
February 4.
February 4. Sorry, my
You
lord.
see,
February
you
4.
see, I'm mutilating my records.
I'm so sorry, my lord.
And then the second one,
9th
February.
February.
9th February. The other one was 4th of February, and the other one was
9th
9th
of
of
February.
February,
Yes.
2009.
Okay. This is the first. This is 4th. This is 9th. 9th. They are the same.
So this is the first. So this is the 9th.
Master Okon.
This one. I'm trying to return. So this is the 9th. 9th February. I saw this one. I didn't know how it should.
My lord,
Yes.
I have seen a document that appears to me clearly a photocopy.
I have seen a document that
Yes.
appears to me purely a
letter.
photocopy.
Yes, 4th of February, 2009.
You said?
I've seen it's dated 4th of February 2009. It's a photocopy. There is no indication of anything that would have gone through a computer.
There is no indication.
There is no indication on this photocopy.
On the photocopy.
Yes, that it has gone through a process of printing.
That it has
through a computer.
Gone through process.
Or email. There is nothing.
Process of.
Yes.
That is not gone through process of.
A computer process by way of email.
Let me get you right. You are saying there is no indication on the photocopy that it has gone through a process of
email. That it could be printed out from.
That
the photocopy could have been printed out from. The original of this document has not been produced.
The original?
Yes, has not been produced.
Is it both of them or only one? You are contending?
My lord, In this,
There are two documents there.
no, but still give me as one.
Okay, the one in your hand.
Yes, this is what I have.
Okay.
There are two documents now. Why are you playing on words?
Please tell me which document is you people and hand it over
Yes.
to me.
I'm sorry, my friend, just playing on words. I have informed the court about
Certainly, I have recorded that. You see,
with
the
two different dates. Letter of offer and letter of acceptance. And he's saying it is one document. I don't think we should go to this extent. The time is fast spent. Must you not close your eyes to something that is very clear?
Detach them if that is his problem.
My lord, I've detached it. I've detached it.
Okay.
Yes, one.
So,
Staple it to. Staple it to.
wow. Put it together for me. My lord,
Yes.
now this is what he
You
described.
are saying the original of these documents?
The original of this document has not been produced.
Have not been produced.
Yes, my lord.
Have not been produced. That's what you're
Yes,
saying.
yes, have not been produced. My lord, on this other plain paper, if it's because it was attached together, on this one that I saw the 9th of February 2009,
With regards to
the other paper titled Acceptance of Employment.
to the other paper
Yes, titled Acceptance of Employment, dated 9th February 2020, 2009.
dated
09.
dated 9th February.
February 2009. There is nothing showing that this also passed through a process. It has not been signed. So, my lord, on that basis, I will object to the admissibility of these documents.
I'll respond to you. Because I want to respond to his objection.
Naturally. Yes. What's your reaction?
My lord, admissibility of document generally is governed by 3 broad factors. The first one is whether the document is pleaded.
It's governed by 3 factors.
3 broad factors. The first, my lord, is whether the document is pleaded. The second is whether it is relevant. The third, my lord, is whether it is admissible. My lord, the document sought to be tendered, for which objection has been raised, is pleaded copiously and front-loaded. Secondly, my lord, the cross of dispute.
Hold on.
My lord, secondly, the crux of this suit is the failure of the defendant employer.
The crux of this suit?
Yes, is the failure of the defendant employer to pay the employee his due salaries without terminating his appointment. So to that extent, my lord, that letter sought to be tendered. They are purely...
Let me get you again.
As a couple.
Secondly, the crux
of this suit,
of this issue is the failure of the
second defendant employer
to pay the claimant employee.
Yes, his salaries without terminating, failure to terminate his appointment.
Without terminating
his appointment.
And
to that extent, my lord, the documents ought to be tendered, being letter of offer and acceptance of offer is purely relevant.
That's the
letter dated 4th February 2009 and 9th February 2009. Offer and acceptance, respectively, is relevant. My lord, the third leg as to whether this document is admissible.
Thirdly.
Yeah. Thirdly.
Yes.
The document sought to be tendered in its form is purely admissible. The witness has given evidence, oral evidence, how he procured those documents via mail, and he printed it out. What is more, my lord, the witness, in compliance with Section 84(2) of the Evidence Act, 2011, has also made a certificate relating to this document, which he said some were procured via mails. Assuming, my lord, without even considering that there is no certificate, the witness has laid oral evidence that will suffice for this document to be admitted. Very importantly, my lord, the witness has not said the document is photocopy.
The witness
has not said the document is photocopy. For issue to even arise as to the whereabouts of the original. My lord, with respect to my learned friend and senior, my learned friend was not even, he was not even definite as to his position on the objection. He only said it appears to him the document is a photocopy. A computer printed document, my lord,
when he said it
appears to him is a photocopy and not the original. My lord, a document printed via computer can be as faint and worse faint than even a photocopy, despite the fact that the computer printout.
You're saying a document
printed by computer can be faint in printout even more than a photocopied document. My lord, with respect again, my learned friend seems to be confused because of the fact that the email is not on that document. My lord, with respect, that is not the issue here. The issue is that
the email.
Yeah, the email, there's no email on the document in his submission. My lord, that argument is as empty as a bird's nest in winter. as the issue is to the document sent and printed out. My Lord, without belaboring the court too much, the document having crossed, having sufficiently passed all the 3 tests of admissibility, and being in compliance with Section 84(2) of the Evidence Act 2011, in whatever form it is, that document, my Lord, with respect, is admissible. I most humbly urge, my Lord, to discountenance the submission of my learned friend in its entirety, admit the 2 documents dated 4th February 2009 and 9th February 2009, and mark them as exhibits before this court. My Lord, once again, I'm very grateful. Unfortunately, we are belaboring the court by these arguments, which ordinarily the court should have been spared with the trouble. I'm grateful, sir.
Very well.
My Lord, sir, I don't intend to, like I said before, I don't intend to respond to some of the language engaged by my learned friend in addressing me. I don't intend to respond, but I want to appeal to the court to direct him to have this sense of decorum as a lawyer.
Noted, henceforth.
I don't intend to respond,
Yes.
but let him have that sense of decorum as a lawyer. He should be able to do that and efficiently too.
I think don't drag this too far.
Thank you, sir.
It is not even worthy of contesting.
My Lord, I don't think I should respond. I don't think I have used any word. As the court pleases.
Yeah.
I'm grateful, sir. I'm grateful for the protection, my Lord.
What is the last exhibit there? CW8. I have this position. It is at the stage of tendering the documents which are identified by the witness as CW1 in evidence, which documents are the ones of 4th February 2009, and the other one the one of 4th February 2009, and the other one of 9th February 2009. That the counsel for the defendant rose objections as to the tendering of these documents in evidence for the purpose of they being admitted in evidence. The defense counsel stated his reasons in his submissions herein above contained, which are basically responded to by the claimant's counsel. I have listened to the arguments canvassed by both counsel as to the admissibility of these two documents in evidence. I so much agree with the contention and line of response of the claimant's counsel, wherein he submitted that what governs the rules of admissibility of a document in a matter are three. He submitted that, one, the document must be one that is pleaded. Secondly, that it is relevant. And thirdly, that the document is admissible. I have carefully looked into the pleadings filed by the claimant, as well as the witness statement on oath. Both of which made reference to the documents sought to be tendered. More so, the documents are front-loaded in accordance with the rules of practice of this honorable court. I also found that since the documents are pleaded, and referred to in the witness statement on oath, as well as front-loaded, it is clear that they have passed the stage of being relevant in the trial. More so, arising from the two above, it is clear that the documents are admissible, since the witness has stated the background from which the documents were procured, i.e., being from the emails mentioned by the witness in his evidence. The law has been settled long ago on the issue of admissibility of document in a trial. That is to say, the three tests stated above are a qualification for the admission of a document in evidence. In the case of Ogule against Aina and others, 2010 LPELR 4694 Court of Appeal, where Section 1 and Section 2 of the Evidence Act 2011, now Section 4 of the Evidence Act, has been restated that the cardinal consideration in admissibility of a document is relevance. Also, in the case of Agu against Wonyi and others, 2015 LPELR 40676 Court of Appeal, the Court of Appeal quoted Section 4 of the Evidence Act and stated that facts though not in issue, which are connected to the facts in issue as to form part of the same transaction, are relevant, whether they occurred at the same time, place, or at different times and place. These documents are generated through computer to which the witness has stated the circumstances. I find them relevant and worthy of admission. Accordingly, I overrule the submissions of the defense counsel and admit the documents in evidence, and accordingly, I mark them as exhibits CW9 and CW10, respectively. That is to say, the letter of 4th February 2009, exhibit CW9, and the letter of 9th February 2009, exhibit C10.
As the court pleases. I'm very grateful, my lord.
Okay. Yes.
Witness,
Yes, my lord.
you also referred to documents, certificate of registration of 2 foreign companies, Notorious Supply and Trading Limited, BVI, and Notorious Supply and Trading Mauritius, in paragraph 11.
Yes, my lord.
And also referred to
Paragraph 11 of what?
of his additional written statement on oath to the certificate of incorporation of 2 subsidiary companies in paragraph 11. I'm grateful, my lord. You also referred to share certificate of Notorious Supply and Trading Limited in paragraph 12.
Yes, my lord.
As God please.
Share certificate of
Notorious Supply and Trading Limited, British Virgin Island. Share certificate.
Come again.
Share certificate of Notorious Supply and Trading Limited, British Virgin Island.
BVI.
BVI, as God pleases. In paragraph 12. And also in paragraph 13, you refer to special resolution of Notorious Supply and Trading Limited, BVI, transferring assets.
I referred to the
special resolution
of special resolution of what?
Of Notorious Supply and Trading Limited, BVI, transferring its assets and liabilities to Notorious Supply and Trading.
Transferring its
liabilities
and assets
to Notorious Supply and Trading. And also in paragraph
Mauritius.
14. Yes, Mauritius.
Paragraph 14.
Paragraph 14, you refer to shareholder register of Notorious Supply and Trading Mauritius Limited. Shareholder register of Notorious Supply and Trading Mauritius Limited, showing
Notorious
Supply and Trading Mauritius Limited, showing 100% holding in paragraph 14. Now, once again, tell this court how these documents were procured.
They were procured by email from Notorious Chemical Industries, PLC. And I print them out. I can't see my lord again. Is that internet? Lagos has dropped off. Lagos has dropped off.
We have lost connection with the court completely.
Oh, okay. So what are the options?
Well, let's still wait whether they will rejoin.
Mr. Ariwale, we'll be with you shortly. We have a power outage.
Okay, we've been wondering. Readily.
Yeah, okay, sorry about that.
Thank you, sir.
All right.
Can you use it?
You know, I must confess.
Oh yeah, the ID is 99.
One of the things you can see also is to have a backup from this. Yes, yes, you have a backup so that if there's power outage, you can compensate for an hour. No problem.
Okay, you're connected already. Abi? Who is that?
Yes, I can see you, Barrister.
Okay. You can hear me.
But not too loud.
Yes, you can't be as loud as before.
Yes, but anyway, we'll try.
Yes.
You have informed the court that those documents were procured via email.
Yes, my lord. and printed out.
As the copy is. Lord, we humbly wish to
Okay for speaker.
The documents. Certificate of incorporation.
Heritage needs to mute because it's echoing. My Lord. Yeah, heritage needs to mute because it's echoing from there. Go on, sir. I can't hear. I'm not hearing you.
Certificate of incorporation of NSTL. Huh?
Yes, NSTL.
Two.
BVI.
BVI.
Yes, Lord.
In bracket?
Yes, Lord.
Okay.
Certificate of incorporation of NSTM Limited, Notorious Supply and Trading
Certificate.
Limited.
Certificate of incorporation. This is another one.
Yes, sir.
Certificate of incorporation
Of Notorious Supply and Trading Mauritius Limited.
Notorious Supply and Trading Mauritius Limited.
Share certificate of Notorious Supply and Trading Limited.
Share certificate of notary. Notary what?
Supply and Trading Limited.
This is the third one.
BVI. Special resolution of Notorious Supply and Trading Limited. BVI. And shareholders register of Notorious Supply and Trading Mauritius Limited.
Yes, show him. Show Mr. Kon.
Why not, because of what was said,
You're objecting of these ones. Oh, okay. That's another way of doing it. It can. Yes. Let me record you. I have objection to tendering of these documents in evidence. However, I reserve my reasons, which I intend to incorporate in my final written address in this matter. Is that so? Okay. The 5 documents herein above mentioned, which were applied to be admitted in evidence, and notwithstanding the objections raised by the defense counsel, whose reasons are to be given at the stage of final written address, are hereby admitted in evidence and marked as exhibits CW11 to CW15 respectively. That is to say, certificate of incorporation of NSTL BVI CW11, certificate of incorporation of NS and TM Mauritius Limited CW12, share certificate of notary supply and trading limited BVI CW13, special resolution of NS and TL BVI CW14, and shareholders register of NS and TL CW15 respectively. Yes, Council.
I can hear you.
Finally, in paragraph 20, 22,
Is there a way you can speak up, my lord?
20 and 22.
Yes.
Can you hear me?
No, really.
And Mr. Okon is not with us.
Not really. I couldn't hear you.
My phone is short.
Okay. Hello?
Yeah, it's better now.
Yes, in paragraph 20 and 22.
The other phone should reduce the volume and possibly mute for Nuruddin or something. That's why it's echoing.
Hello? Yes. Paragraph 20 and 22. We refer to
I can't hear you again. Yeah, I can't hear you. Yeah, I can hear you now.
Okay, thank you. Paragraph 20 and 22 of your additional written statement on oath. You refer to copies of reports.
Yes, my lord. I can't hear you again. I can't hear you again if you're still talking. I can't hear anybody.
Yeah, speak.
Yeah. Redmi is the one echoing. Sorry, if everybody mutes and only the person speaking on mute, it will be very clear. Everybody will hear.
Can you hear us?
Fair now, but it's echoing.
Okay.
Yeah.
Yes, Council. Paragraph. You mentioned
Yes, 20 and 22. We refer to two.
Not again. I can't hear you again.
So 2009.
agreement. Agreement dated what?
26 October 2009.
Yes.
You have said that one.
And also copies of reports.
Copies
Yes,
of
my
report.
lord. I'm not hearing. I'm not hearing anyone.
Can you hear me?
Yes, I can hear you now. Though echoing, I can hear you.
Can you tell the court how the documents were procured?
Those documents were procured by email and I printed them out in the same manner as the others.
My Lord, I want to tender the documents as exhibit. This one was not front-loaded, but loaded. This one is 05, but not front-loaded. The other one is there. That one is not front-loaded. Yes, it's there. It's attached. Check your additional amended claim. Is in your amended claim, but the other one is not front-loaded. This one. The document dated 26 October 2009. The one on paragraph. That's the copies of reports. The other one is the two are mentioned, the two are pleaded, but the FOB agreement was not attached to the document. The two of them. The copies of reports in paragraph 20. Paragraph 20. And the FOB agreement dated 26 October in paragraph 22. And 22. This one. Yes. So it was front-loaded. I'll give you a copy. It was split, but it was not front-loaded.
It was pleaded there was no front-loaded. I have no copy of maybe you give me a copy. I will reserve, I have my objection to it. I will reserve my objection. I have objection to it. And maybe my learned friend can also give me a copy.
I'll give you a copy.
Because he has been working from me.
I'll give you a copy. My lord, I'll give you a copy. And even now.
It wasn't from me, according to him.
No, no.
I can't hear you. Nuruddin, you are muted. I can't hear him. I'm not hearing you again, though. I'm not hearing anybody. I'm not hearing. Nuruddin, you are muted. I can't hear you, my lord. Okay. I can't hear. I can't hear anybody. Nuruddin is muted. I can't hear anybody. Okay.
Yes, just hold on.
Okay. Okay, just okay. Sorry.
This is a seminar. So I will actually ask you.
Thank you.
I'm not hearing no.
Yeah. Don't be guided by the earliest convenience.
Are we still here?
Hello, Mr. Ariwole, your matter has been concluded, so you can log out.
Okay, so I should just talk to my barrister.
Yes.
Okay, who is talking?
You see what you put me through today?
What happened?